Yes, good evening to the students of SLW646, that is Advanced International Dispute Settlement Law is concerned. Yes, I asked the other people also to join. Dorcas joined 2 times. Anyway, it doesn't matter. In our last class that I dealt the immunities given to the regional agencies or the institutions. If the immunities are not there, a institution cannot function in proper manner or without fear and favor. So, in this class, we will see that institutional arrangement, competence, and procedures concern. So, there we will also discuss the regional agencies, institutions in resolving the international disputes in amicable way. So, if you happen to see here, and which I highlighting because I don't know whether you could see it or not, I would like to magnify it so that you could see it. And I already posted this thing to your email just now. So, if you happen to see the institution arrangement, competence, and procedure, and we need not worry about the paragraphs and other things are concerned. But we can start with that only point here is section 3, which follows, on the other hand, concentrates on some example of the dispute settlement in which various regional arrangements or agencies have been involved. In the dispute settlement, the regional agencies are the institutions involved to the extent to some institutional aspects contained in the present section may be illustrated by means of the example, the dispute settlement described in the section 3, the appropriate reference also made. So the section 3 of the charter is there, UN charter, from there you can tap it. But we cannot remember the articles, we cannot remember all the sections, and hence just we can say the UN charter, one of the sections deals with the institutional arrangement of the competency and the procedure to resolve the international dispute in an amicable way. Are you following me?
Yes, Prof.
Very good, very good. If you have any difficulty, please bring to my notice, okay?
Okay, Prof.
Right. So now let us see, because when you say the regionals, I discussed it in my last class. There is a League of Arab States, there is a African Union, and there is also the American setup also there. We'll throw light on only few aspects of it, not entirely the things. So let us see what is the League of Arab States. I already told you. And who are the members in the League of Arab States? Anyone? Who are the members in the League of Arab States? Can the Tanzania is one of the member? Yes. Petroleum exporting countries, OPEC. Organization of the petroleum exporting countries in that region. Of course, Middle East comes and Saudi Arabia comes and the UAE comes in that region. So, Article 5 of the League Pact provides for an arbitral role for the Council of Leagues, which is composed of a representative of all member states. Here, all member states means it doesn't mean that Tanzania and India will come over there. If a dispute between the two contending members of the League does not involve the independence, sovereignty, or territorial integrity of the state, and those members apply to the League Council for the settlement of the disputes. Who will make the settlement of the disputes? Those who are the members of the League of Arab States. Is it clear?
Yes, Prof.
And I don't think Tanzania is a member of the League of Arab States because it doesn't come under the jurisdiction. Am I right?
You're right, Prof.
It comes under the African Union. So now let us see that how it can be made. So those who are the member states to resolve their disputes, and this League of Council will make it out, other League of Arab States will come forward. So here again we want to say is here, yes, League Council for the settlement of the disputes, the decision of the League of Council shall be the effective and obligatory. The exercise of the council function as an organ of the arbitration is, therefore, subject to the two conditions. And these League of Arab States or the League of Council will come to the rescue to resolve the disputes among the people who are the state, who are the members of this League of Council. So the council functions as an organ of the arbitration is therefore subject to two conditions. What are they? A, party submission. That means the member of the League of State should have to submit that, yes, we will bind to this League of Council. Means consent of the party should be there, number one. And B, subject matter limitation. Even the subject matter limitation, like we told you, even a district court or residence magistrate court have the subject matter jurisdiction. If the subject matter jurisdiction is more, either in the pecuniary value or cause of action, then automatically it will be commuted to the next court, the higher court. Is it clear? Is it clear? Jurisdiction and cause of action. If you did not file in a proper court, the court will direct you. No, you file the case in the so and so because this court doesn't have the jurisdiction to entertain it because cause of action is more. Yes, Margaret Moseva, and I believe that you are the first year of LLM, but doesn't matter. At least you could have an experience to see how the class is going on the online. Am I right? Margaret Moseva, unmute and speak. I don't know whether she knows the unmute and mute. Margaret Moseva, there are two buttons are there. Dorcas, explain her.
Yes. Hello.
No, hello, I could hear you. Are you a student of the first year?
Yes, I'm a first year student.
Very good. At least you can have the experience how Professor Hussain will teach. Just observe it. When I ask the question to you, you give the reply. Now you mute. Now you mute.
Hello?
I say now you
I can
mute.
mute you. Okay. Okay, thank you.
And you can observe how I teach the class. You did not mute it.
Yes.
You mute. Yes, now you muted it. Now you observe how I am teaching the class. Okay, now let us come to the point. Here we are dealing about the league. They depend upon the two factors. One is the party submission and another is the subject matter limitation. And I told you that what is the subject matter limitation? Because every court having its only the jurisdiction. How many jurisdictions the court having in general? Like for instance, you take the municipal court. Anyone can unmute and give me the answer if you know it. If you don't know it, says pass on. Don't kill the time.
Repeat the question, Prof.
How many types of the jurisdiction each court is having? Did you understand my question? Raymond Cosmos. Where is Lema? Lema disappeared. Yes, Margaret Moseva. Can you give me the answer to my question? How many jurisdictions you know of a particular court?
Prof, I did not hear you.
Yes? Repeat the... Again, I ask the question. How many jurisdictions a court is having?
There's territorial jurisdiction,
Yes.
personal
Pecuniary
jurisdiction.
jurisdiction.
Yes, I appreciate. I appreciate. I appreciate Margaret. And cause is a subject matter also. In addition to the geographical or territorial jurisdiction, in addition to the pecuniary jurisdiction, and the subject matter also falls over there. For instance, you take the murder case. Can the murder case will be dealt under the a ordinary court? It will be filed only either in the session court, most probably. And the murder case will be filed in the session court or subordinate court. Then, if the life sentence is given, hanged to death sentence is given, that should be sent to the High Court for the endorsement. The High Court will look into the matter again, they will confirm it. So, what I want to say is, subject matter also the jurisdiction will be there. If the subject matter is a different, nature of the case is different, then automatically the lower court doesn't have a jurisdiction to entertain a case. For instance, you take election commission. Election, if you want to file a case in Tanzania, could you file it in the residence magistrate court or a session court?
It depends, Prof.
No, they cannot entertain the election commission. Only the High Court is having the jurisdiction. In India,
Not only High Court.
yeah, in India, there is the election commission is there, tribunal is there. First, you have to file a case in the election commission. If you fail to get if you are not satisfied with that one, then you can approach directly to the Supreme Court. Because it is equivalent to the High Court in status. Am I right? Did you get my point now? Say yes or no.
Come again, sir.
Yes, I appreciate Margaret. So what I want to convey to you is no, it is a party submission should be there for the jurisdiction and subject matter of limitation. What is the subject matter would be there and what is the limitation would be there. So agreed party will approach to the League of Nations, those who are come under the geography. When the council acts as an arbitral capacity, the League of Council, the states among which the dispute has arisen shall not participate in the deliberations and decision of the council. If the state will not participate in the deliberation, yes, somebody is speaking because I don't think that they kept it. Let me check it. Whether they, yeah, now you keep it in the mute. Yes, I appreciate. Yes, now the League Pact also provides the council shall mediate in a dispute which that lead to the war between the two members of the states or between the members of the state and another state in order to conciliate them. So, when the party agrees to the League of Council and the subject matter comes under the League of Council, at that instant, the League Pact also provides that the council shall mediate in the dispute which will lead to the war between the two members or war or any dispute, doesn't matter, or between the member states and the another state. So the member states should have to give the consent and the subject matter also comes under it. Then under the article of the League of the Pact, yes, they can amicably settle the dispute without encroaching on anybody's state sovereignty. So, the exercise of these functions of the good offices, I already discussed what is the good offices, and I already discussed what is the mediation, and what are the conditions should be there in the conciliation, does not depend upon the submission of the dispute by the parties. So, the exercise of those functions of good offices, those who are the mediator, and they give the office to adjudicate the case. Mediation and conciliation does not depend upon the submission of the dispute by the parties. Merely submission of the party will not be the point, but they have to participate in the deliberations. So that is what I want to impress. So in practice, the council has applied the modes of good offices, mediation and conciliation to all disputes, whether priest threatening or not. If it is a priest threatening is there or not would be there, yes, all the cases will be entertained by the League of Council or Arab League, those who come under their jurisdiction, and the dispute will be resolved. So while in some cases it has done so directly, in other cases it has set up subsidiary bodies to carry out this function. Sometimes they can directly involve over there, and sometimes they can send their representatives, subsidiary bodies to represent their case. Suppose in the civil cases, could the party should be present or the party advocate should be present? Anyone can unmute and give me the answer.
The party representative.
In the civil cases, on behalf of the party, the advocate will represent. Am I right?
Yes, Prof.
Because Wakalat Nama is there. You know what is Wakalat Nama? Wakalat. What do you say? What is the word that you used here? The party will give the full authorization to the advocate to represent his case. What is that form? What do you call that form name? Where authorization given the parties to the advocate? Don't say power of attorney. Party friends, give me the answer. Your silence will kill me. Either you say I don't know or you say pass on.
Person.
See, whenever the civil case should be there, on behalf of the party, the advocate will represent it and they will sign an agreement. In India, we say Wakalatnama. Means he represent Margaret. Are you following me? From your side, I am getting the sound. Yes, when you want to speak, you can unmute at the time. When you don't want to speak, you can mute it. So that is the representation should be given by the parties to the advocate. The advocate will represent it. So it will also be noted that when the Pact of the League does not expressly provide the participation in the Secretary General in process of the peaceful settlement of the dispute. So it does not mean that they should have to participate in the Security Council because it is a matter of the regional office. It is a regional, if they are not satisfied with the regional offices, then you can approach to the Security Council. For instance, if you are not happy by the decision of the Residence Magistrate Court or a district court, where do you approach?
Prof, I have a question.
Yes, please ask.
In the pact, who appoints the country for good offices? Who appoints the state for good offices?
See, it depends upon the country, depends upon the state. They can choose. If the two party will choose the good office of another country, yes, they can agree it. But only the point is that country should be one of the member of the League of Nations, League of Arab League.
What happens when one of the party does not agree with the choice of the state or the country for good
Yes,
office?
suppose if they are not happy by the Arab League or a League of Council decision, the agreed party can go to the Security Council because Arab League is a regional one. Like if you are not happy by the District Magistrate Court decision or the District Magistrate Court decision, then where do you approach? High Court.
High Court.
If you did not feel happy with the High Court decision, where do you approach?
Court of Appeal.
If you are not happy with the Court of Appeal, then what do? You make the review petition. Am I right?
Yes.
Yeah, there is a provision is there. And here also provision. If you are not happy by the League of Nations, this Arab League, the League Council decision, yes, you can go to the Security Council. And that is the same thing which he has made here. It also be noted that while the Pact of the League does not expressly provide for the participation of the Security Council in the process of the peaceful settlement of dispute, the Council through the internal regulation has developed an active role for the Secretary General in this correction. Often, the Council has included the Secretary General of the League in the special bodies has created for its mediation of fact-finding missions. If the regional officers you are not happy by that one, then you can approach to the either a General Assembly or the Security Council. Both the way you can approach it. Where it is deemed fit. If once they made the decision, it is a final. Is it clear?
It is clear, Prof. Thank you.
Okay. Now that is the and only member state. Please note the point. Only member state of the League of Nations. I mean Arab League, League of Arab States, and those can go over there. Let us throw light on the organization of the American states. If you throw light on the regional American states, of course they are given the Chapter 4, Article 23 to 26 of the Organization of the American States Charter deals specifically with the peaceful settlement of the dispute, and Article 23 deals, as amended by the 1985 Protocol of the Cartagena de Indias, provides that the international dispute which may arise between the American states shall be submitted to the peaceful procedures set forth in the Organization of the American States Charter. Under the charter, there are members who are there, and those members only will represent to the Organization of the American States. Although that should not be interpreted as an impairment of the rights and obligation of the member states under Article 34, 35 of the Charter of the United Nations. See, you can become a member of states there. It doesn't mean that you cannot approach to the United Nations. Yes, you can approach. When you are aggrieved by the Organization of the American States. Because under the charter where the members are there. So, here they said, although this should not be interpreted as an impairment of the right and obligation of the member states under the charter, Article 34 and 35 of the Charter of the United Nations. It is not an impediment to them. Still they can evaluate if they are not happy by the decision of the Organization of the American States. Then specific mention is made in Bogota Charter of the direct negotiation. This is another charter. The charter says direct negotiation, good offices, mediation, investigation, and conciliation. These are all the diplomatic method of resolving the legal disputes. Judicial settlements, it is through the institutions, judicial authorities, and arbitration, as well as the other means of choice of the parties to a dispute. Now the question comes, if the party agrees together by any means of diplomatic settlement, yes, they can do so. They need not to approach to the even Organization of American States. So Article 26 contains an express reference to special treaty establishing the adequate procedure for the peaceful settlement of the disputes and the means of their application. What is all the motto our is? Our motto is peaceful settlement of dispute without encroaching the state sovereignty. Is it clear? Say, unmute and say, is it clear?
Yes, clear.
Appreciate. So this is the American Treaty on a Peaceful Settlement. This is a Pact Bogota is another a treaty, and this is based on the American Treaty of Specific Settlement of the Pact of Bogota. That is of 30th April 1948 they made, which contains a detailed provision of the above mentioned procedures in addition to certain general principles, regarding the peaceful settlement of dispute between the American states. Who are the members of the Organization of the American States? Those members could resolve their disputes in amicable way in this matter. In addition to that, one Bogota Pact also there, which made in the 1948, and they come forward to see that there would be a peaceful settlement of the dispute between the member states. So it also to be noted that amended 1970 and again 1985, the amendment would come like what we have the amendment now in our act also. So either the 1970 and 1985 amendment to the Organization of American States OAS Charter endorsed the Permanent Council for the organization and composed of one representative of each member state with a function in the field of the peaceful settlement. Now, who are the members in the settlement of this dispute for this under charter? Of course, each and every member cannot be a person represented over there. Especially the matter comes over there. Those who are having knowledge in the dispute settlement, having a knowledge in the law, and they will be a member and act like a judge in the dispute settlement in this pact or in these regional agencies. So the exercise of the functions may be initiated by any party to dispute in which none of the peaceful procedure provided for the OAS charter is underway. So the charter gives a clear-cut way. These are the things which should be there. If they are not happy by the charter of OAS, but they have to apply it. If they are agreed by that one, they can go to the either General Assembly or the Security Council as a appeal in the form of appeal. So if any or all of the parties to dispute request the good office of the council, the latter shall assist the parties and recommend the procedure it consider suitable for the peaceful settlement of the dispute. Suppose the parties agrees for the good office of a member states, then they will make amicable settlement. They will arrange it also. Who? OAS. Who is OAS? Organization of American States. Is it clear? Is it clear? If any,
Yeah,
all of the parties to dispute.
yeah.
Yes. The good office of the council later shall assist the parties to recommend the procedure it considers suitable for the peaceful settlement of the dispute. In the exercise of this function, the council, with the contents of the government concerned, any resort to fact-finding activities in the territory to one or more parties to the dispute. I already told you, there is a fact-finding committee is there. Who will make it out? Security Council will make it out. To go and search what is what exactly. And they will give the report. And such a report can be submitted to either to the regional agency or for their own sake, because if the party comes to their as an appeal and they will see that the fact-finding committee has given the report to it, and hence they will give the decision based upon the fact-finding committee report. Like a commissioner. You know, commissioner is appointed in the courts. Commissioners are appointed in the court to see that a court will not go to the place, dispute place. Who will go to the dispute place? Participants. Participant Margaret Moshev, can you give me the answer? Are you a practicing advocate? Are you a student?
A state attorney.
Yes?
I'm a state attorney.
Okay, very good, very good. Do you know what is the commissioner?
A commissioner for
A commissioner will be appointed by the court. and the commissioner go to the dispute place and observe it and send the report to the court. In the same manner, there is a fact-finding committee would be there, appointed by the Security Council. They go to the place where the dispute is there, and they will observe all the proceedings in the particular state, and the state should not stop them. Like commissioner, you should not stop them when they are doing the commissioner work. Is it clear?
Yes, it's clear.
Because court will not go to the dispute place. A magistrate cannot go to the dispute place. A commissioner will go. Because it's the magistrate appoint the commissioner act as a judge and go to a particular place and make the reports. So it also may be with the consent of the parties to the dispute establishes ad hoc committees with the membership and mandate also to be agreed by the parties. So a regional agencies, regional courts, rather we can say, or institutions will try to resolve the dispute among the parties, those who are the members of the regional, like we discussed, Arab League is one of the, then Organization of the American States is one of the, so those who are charter members, the dispute could be resolved by those people, those member states only. So furthermore, Article 87 of the OAS, that is the Organization of the American States Charter, as amended in 1985, provides that if the procedure for the peaceful settlement of the dispute recommended by the Permanent Council or suggested by the Permanent and Ad hoc Committee under the terms of its mandate is not accepted by one of the parties, or one of the parties declares that the procedure has not settled the dispute, the Permanent Council shall so inform the General Assembly without prejudice to taking step to secure the agreement between the parties to restore the relations between them. If any one of the party will not listen to the dispute, at that instant the Permanent Council will give the direction to other state or to the state to follow the whatever the statement is given to them. So the Permanent Council shall to inform to the whole General Assembly without prejudice to its taking steps to secure agreement between the parties to restore the relation between them. So the matter will be referred to the Security Council. When the Security Council will take an action, if any party will not obey, what the action will be taken by the Security Council? Economic sanctions, diplomatic sanctions, and they will force that the state should have to obey the norms of the charter. If not, there will be sanctions against them and the boycott to them, and diplomatic relations will be curtailed. Did you get my point? Libya also did not agree to the Security Council decisions. So economic sanctions against the Libya was there. So all the flights, all the countries, they boycotted the Libya. Of course, now the economic sanctions are removed because now normalcy has come out. So that is about the organization of the American states. It is one of the regional agency, a regional body. Then comes to the organization of the African unity. In the African unity, when you say Tanzania comes over there, all African nations come over there. Who are the members of this African Union? So article, can you tell me what is this? Margaret Moseba, I highlighted something here. Can you read? Article? Say article.
Sorry?
Which I highlighted there on the screen.
Article 19.
I appreciate. Those are the Roman upper class. This is 10.
Yes.
And this is 1 is kept it here means it is 9. So 10 plus 9, 19. So Article 19 of the OEU means Organization of the African Unity, Charter lays down the principle of the peaceful settlement of dispute and provides for the establishment of Commission of Mediation, Conciliation, and Arbitration, whose composition and conditions of service shall be defined by the separate protocol to be regarded as an integral part of the Charter. In all this organization, there is a diplomatic method of the resolving the disputes are there. What are the diplomatic methods of resolving the disputes? Mediation, conciliation, arbitration, good office. If they are not solved over there, then the judicial institutions, means judicial declarations, judicial settlements. If it is not over there by the regional way, then they will approach to the Security Council or the permanent member or the General Assembly. That is the last resort to them, whose composition and conditions of service shall be defined by separate protocol to be regarded as an integral part of the Charter. So OAU also having the Charter, and it is having their own method of reconciliation, method of the diplomatic means, and they try to resolve the dispute by following that matter. Margaret Moseva, you did not mute it, that's why I'm getting the sound from your house. Your dialogue in the house, I could hear you. So when you speak, you unmute. When you don't speak, you mute it. Okay? Mute, Margaret. You did not mute it.
Give a message.
Margaret, you mute your microphone. If you don't mute it, I get the sound. Of course, when you don't mute, you don't speak. So that is the method. Charlie Joyce is joined just now. Okay, Karibu Sana, Charlie Joyce. I believe that you are also the first year student. Okay, Karibu Sana. And we are dealing about here the Organization of the African Unity for the people SLW646, second year, first semester. So here, the said protocol was signed by the Cairo on 21st July 1964 and contains the detailed provisions on the establishment of the organization of the commission or a general principle on the procedure to be followed in the case of the mediation, conciliation, and arbitration. So in 1964, it is made in the Cairo. Do you think that Cairo also one of the member in the African Union? Charlie Joyce?
Please read the
Yes?
Yes, sir.
Answer is yes. Because Cairo, which country comes Cairo?
Cairo, Egypt.
Egypt, it will come over there. So Egypt also one of the member in the African Union, and a dispute may be referred by the commission jointly by the parties concerned. If the party choose it, they can refer the matter to the commission and a party to the dispute by the council of the ministers or by the assembly of the heads of the state and government, the government head of the state or the representative from the government of the state will represent when there is a dispute among the parties, those who are the members of the African Union. So if a dispute has been referred to the commission, one or more parties have refused to submit the jurisdiction of the commission, but a bureau refer the matter to the council of ministers for consideration. If any one of the state will not listen to the council, which is made under the African Unity, then they will send the representation to their government. What way? They will write to the government, council of ministers and external affairs ministers to see that it should be considered. The matter should be considered to them because they are the parties to the African Union. On the other hand, the consent of the party may be expressed by a prayer agreement or by an ad hoc submission of the dispute or by the acceptance of the other parties, other councils or assemblies' submission of the dispute to the commission is jurisdiction. How a party will give the consent? By the implied consent, by the express consent, the party will make it out. Suppose the state party will not make it out, then the African unity will force their council minister to reconsider it. If they don't do it, then economic sanctions or diplomatic sanctions would be against that country who did not follow such a charter of the African Union. So that is the point. The commission is endowed with the powers of the investigation. Even the African Commission is having the power to the investigation or inquiry with regard to the dispute submitted to it. So whatever the dispute submitted it, they can send the inquiry, make the investigation on it. So in accordance with the protocol, the parties to the dispute may agree to resort to any one of the following modes. So they can make it a resolve it. Suppose the both party agree together to resolve the legal dispute. Can any organization will say that don't do like that? Answer is no. Because the party themselves only want to resolve the dispute. If the wife and husband resolve their own dispute, can the neighbor will come, why do you want to resolve the dispute? Can he interfere in that matter? Yes?
I didn't get the question really.
Okay. If the wife and husband dispute is there, can the
Yes.
third party will interfere in it?
If that third party is also the party to the contract to that whatever union.
No, I am asking about one example I am giving. The wife and husband dispute is there.
Mm-hmm.
Can the third party interfere in it?
I don't think so.
Why the third party will interfere in the dispute of the wife and husband? Unless until either the wife or the husband will agree to the verdict or say of the third party or invite the third party. Is it clear?
It's Prof.
That means when the parties to the African Union agree together to resolve their dispute by amicable solution, by the mediation, by the conciliation, by the arbitration, by the good office, nobody will come interfere. So let them do what manner they want to resolve their dispute. So these three modes are alternative use and not necessarily the successive procedures, and parties are free to use any one or all three in the respective disputes. They can opt any one to resolve the disputes, either by the settlement or by the mediation or by the conciliation or by the arbitration or by the good office. If not, they will submit their consent to the judicial institutions and they will decide the case. So nobody would interfere in that matter when they want to resolve the disputes in the amicable way. So assemblies and head of the state of the government are the organization of the African Union unity with a view to rendering the commission for more flexible or more apt to respond to the agencies of intra-African disputes, decided to suspend the election of the commission's members and provisionally appoint an ad hoc committee composed of the 9 states plus 3 other possible members of the appointed by the OU chairman. Now the question comes over there. Suppose an election is there. Of course, election is a state subject. It is not a dispute between the two states. Am I right? Election
Come
in the
again, Prof.
Tanzania. In the election in Tanzania, can the Kenya will interfere it?
No.
If they want, they can file a case in the election commission. If the election commission will not do such a thing, they will approach to the High Court. Of course, the election commission is equal to the High Court, and they can approach to the Supreme Court. Election commission petition cannot be entertained by either the residence magistrate court or by the district court. Am I right?
It
Please give me the answer. Election commission can will be entertained by the residence magistrate court. In India, a separate commission would be there. You have to file in the commission. If you are not happy by the commission, you can approach to the Supreme Court, even not the High Court, because commission itself is a rank of the High Court. Are you following me? So while the possibility
Yes,
always
bro.
exists for the organization of the African Union to reactivate the commissioner or the ad hoc committee discussed above to practice the OAU had a recourse to other procedures in number of peaceful settlement of dispute issues in which has been involved. So it has to be so thorough. Council of Ministers and Assembly of the Heads of the State and Government through the certain special or ad hoc committees other than the one mentioned in the paragraph above, it has also been used to good offices of some African statesmen. So they will request the head of the institution, head of the states or the Council of Ministers, they will force it to reconsider the thing. Yes, is waiting in the lobby. Okay, I entertained. So the meeting will end in all participants in 5 minutes. Still 5 minutes are there to entertain you. So we discussed organization of the Arab League, where the members of the Arab League will resolve the disputes, those who are member states, and the African Union organization of the African Union there, those under the charter, members of that charter, they can amicably resolve the issues, and the respective government will be forced to undertake it, or the Council of Ministers and the Assembly of the Head of the United States should have to reconsider it. If not, they consider it, then the economic sanctions or a diplomatic sanctions are there, or the regional commission will refer the matter to the Security Council or the General Assembly to see that how the action could be taken if the one of the party will not listen to the charter, under the charter rules. So here again we discussed too the European Convention of the Peaceful Settlement of Dispute that the Council of Europe we will discuss in the next class, because this is also a regional agency. Is it clear? So European conventions, that D is there, is the regional agency to solve the disputes, and then the same, of course, these are conferences or securities or cooperation of the people are there. It is a sub-agencies, they will also take care of it. The sub-agencies, of course, one of the part of it in the Europe. Then we will see that thing also in the next class if possible. And this is the European and inter-American system of the protection of the human rights. We are not touching with the human rights here because we are touching only the dispute settlement in the among the states are concerned. Because the human rights, there is a separate body is there and they will take care of it. Like the Human Rights Commission is there in the Arusha. Am I right?
Yes,
Human Rights Court is there for entire Africa. Where? Where? Human Rights, People's Rights Commission is there for the entire Africa. The dispute in the human rights will be resolved in Arusha. Participants, are you hearing me?
yes, Prof.
But why you are not giving the answer? If you don't give the answer, I think that you
Yes.
did not hear me. So now in the next class, we will see about the European Union regarding the agencies are concerned, and another subsidiaries also given too, and we will see the subsidiaries, and with that regional agency will be cleared. I sent this total book in your email. You check your email and you will find this one. and we don't go through all the aspects of it. We'll pick out only what is relevant to us. Is it clear? Because he has given the
Yes.
EF also organization, but we are not going to deal those things. We deal only Arab League, we deal African Union, we deal Europe Union. Only these aspects only. Is it clear?
Yes.
So at any time it will be stopped. Meanwhile, if you want to ask anything, you can ask. So next class is European Union, that we will deal it. Okay?
Thank you. Thank you.
Yes, yes. See, European Union I am showing here that we are dealing in the next class. And one or two subsidiaries also this. See, we already dealt the Organization of the American States, we dealt it. And this is Organization of the African Unity, we dealt it. See. And we are going to take the European Convention for the Peaceful Settlement of the Dispute. That is the Council of Europe, you have to discuss or deliberate in the next class. So, at any time, the Cisco WebEx will stop it. If you want to ask anything, you can ask. Margaret Moseba, when you want to speak, you can unmute it and then speak. When you don't want to speak, you can mute it. And you have to sit in the such a Sikiliza mimi darasa. Asante sana na shukuru sana. Mungu akubariki na kukulinda.